Hello students, hope everyone is safe and sound. I will repeat the same old formula: stay safe, stay home, and follow all the instructions of the government relating to the COVID-19 pandemic. We will start with the revision lecture series of the subject industrial law. I would also request you to have the textbook and your notes with you so that you can get the maximum benefit from this particular video lecture. We'll start with the topic of Industrial Disputes Act. Now, as you all know, the subject of industrial law specifically deals with the problems or measures relating to improvement of the employer-employee relationship in the industries. Also, it is a very important factor for maintaining industrial peace by establishing social justice. We'll start with the basic objective of the Industrial Dispute Act as already given by the Supreme Court in the case of workers of Dimakuchi Tea Estate versus Dimakuchi Tea Estate. Now, in this particular judgment, the court has given certain objectives. Let me repeat it for you. First is promotion of measures for securing and preserving good relations between employers and workmen. Second, prevention of illegal strikes and lockouts. And third, promotion of collective bargaining. Next would come the important definitions. Any student of industrial law would know that any discussion of Industrial Disputes Act is futile without having to know the basic definition of the term industry. Now, the definition is very simple as far as the law is concerned. That is, it means any business, trade, undertaking, manufacture of any service, employment, handicrafts, or vocation of workmen. That is okay. But then the most important case law as far as this definition is concerned is the Bangalore Water Supply versus A. Rajappa. The court has given three tests or three criteria, as we can call it. First, systematic activity. Second, organized by cooperation between employer and employee. And third, for the production and distribution of goods and services calculated to satisfy human wants. Now, these are very basic things given by the court. We can also say some of the things are not included in this particular definition, what cannot be called as the term industry. First, the things which are related to spiritual services. Say, for example, a temple is not covered under the definition of this industry. Then, absence of profit motive. Say, for example, you are undertaking any hobby. I'm sure that is not for gaining profits or earning money. So that also is not covered under the definition of this term industry. So what is the systematic activity? Obviously, where there is no chaos. That is called as a systematic. Second, organized by cooperation between employer and employee. And third, for production and distribution of goods and services. So it is not in the middle that you can just randomly start anything and then call it an industry. No. There are certain criteria which are being fixed by the Supreme Court. Now, you may think that what is the need for the court to interfere in this matter? It's not like that. We already discussed in previous semester also, that is the business law paper, that there are many things which the legislature or the parliament makes laws on it, but the clarity on these issues are taken up by courts as and when the case arises. This is the beauty of our democracy. Everyone is dependent on everyone. I mean, the institutions are dependent on each other for the working of this democracy. Right? Okay. Going further, industrial dispute, another definition. It also has three categories. One, it is a dispute between the employers and employers. Second, employers and workmen, and workmen and workmen. I think this definition is very much clear in itself. Also, it some kind of it dispels the myth that industrial dispute can happen only between the employers and the workmen. It's not like that. Yes, we can say that majority of the disputes are between the employers and the workmen, but then those disputes between employers and employers, right, and workmen, that are also coming under this particular definition of the term industrial dispute. Now, on what basis? Can it be a personal dispute? Say, for example, Mr. A has given certain amount of money to Mr. B, both are workmen. Now, Mr. B is not returning the money to Mr. A. So, Mr. A, can he go to the labor court or the industrial tribunal or the other authorities saying that please direct or give an order to return my money? No. This is not a person, because this is not an industrial dispute, it's a personal dispute. I'm not saying here that in this particular instance, Mr. A does not has any solution before him. No. He can obviously approach the civil court in a private capacity, and then he can go for the regular things, whatever are there. Right? But the difference should be, or the dispute should be related to the terms of employment or conditions of labor. Right? So, if you remember the third topic which is there, that is the Factories Act, there are various situations given where the factories are being mandated to have certain important conditions as far as the labor conditions are there. If those are not fulfilled, obviously that will be coming under this particular term that is called as the industrial dispute. Now, going further to the next definition, that is the definition of workman. Right? So, what is the meaning of workman? Is that any person, includes an apprentice, you can call it some kind of a trainee, employed in any industry to do any manual, unskilled, skilled, technical, operational, whether the terms of employment are express or implied. Right? Also, it does not include certain things. One, the persons who are working in the, say, army, navy or police. Second, who are employed in a managerial or administrative capacity. In fact, they are given the criteria, that is the employed in a supervisory capacity and draws wages exceeding 10,000 rupees. Those are also excluded from this term, workmen. Right? Next, we will go to the authorities as far as the industrial disputes are concerned. There are three types of authorities or three types of divisions under which these authorities work. One is conciliation, second is adjudication, and third is arbitration. Conciliation, बातचीत जिसे हम बोलते हैं. There are three authorities as far as conciliation is concerned. One is the works committee, conciliation officer, and third is the board of conciliation. Next is adjudication, court जिसे हम बोलते हैं, या फिर judicial sense is there. That was a court of inquiry, labor court, industrial tribunal, and a national tribunal. Works committee. Now, this works committee, I am not calling it informal system. We cannot call it informal because it is there in the act. But then again, like I said, it's more of a informal sense, at least for the workmen, because they find it easier to approach the works committee, which consists of representatives from both the workers and the management side. If any issue is there, rather than go to the courts, they will solve it at their level only. Right? Next is your conciliation officers. So now these officers are appointed by the government. Normally it is the term given here is the appropriate government. So they appoint these officers, conciliation officers, and whose job is to wherever he apprehends or he thinks that there could be some kind of a dispute, then he tries to settle that dispute by bringing both the parties in front of him, and he tries to do it amicably. Conciliation, we had already discussed this term, conciliation. Third is the board of conciliation, more or less kind of a formal authority where consists of chairman or 2 or 4 other members as the appropriate government may think fit. Then let us move on to the adjudication part. One is the courts of inquiry. The term itself is inquiry. So these are not a regular court, the court of inquiry. It consists of a single person, one or more independent persons. This is what the term says. There are very few occasions basically where this court of inquiry has been set up. Normally it has been set up when any big disaster happens. Say for example the 1984 Bhopal gas disaster. If there's such kind of a disaster on such a large scale has happened, then this court of inquiry is set up. Then is the labor court. Now this labor court is there wherein the various disputes related to the industries are being adjudicated upon, and it consists of one person, right? So the person who is heading this labor court is called as a presiding officer, qualifications of a presiding officer are either he has been a judge of a high court or he has even been a district judge for a period of not less than 3 years. What are the powers of the labor court is that it may follow any procedure it may think fit. It may think fit in the sense that they have powers under the civil procedure code, wherein they can enforce attendance of any person, or they can call for any documents, or they can even examine the witnesses. Obviously, in some technical matters, they can also take help of the advisors, right? Then the next authority, that is the tribunal. Tribunal is a kind of an authority which is called as a quasi-judicial authority. It also consists of one person appointed by the appropriate government. So they can be either on the district or the state level, or even on the national level. That is called as the national tribunals. Now going to another topic in this, that is the term called as the strike. Now we all know the term strike because we may have heard it in the media, or that so and so persons have gone on strike, or the workers have gone on strike, or there is a bus strike, transport strike, or whatever strike, bank strike, whatever it may be. Now, as per section 2Q of the Industrial Disputes Act, strike means cessation of work. Cessation, काम रुकाना, cessation, CESSATION. Cessation of work by a body of persons in any industry, or refusal to work at a workplace. Now, there are various types of strikes: pen down, tool down, stay in, sit in, go slow, hunger strikes. I'm sure most of us would be acquainted with this hunger strike, bhook hadtal, what we call it. Now, certain case laws we discussed in the class that I will like to repeat it. First is the Punjab National Bank versus AH India Punjab National Bank Employees Union. Now, in that the court held that it would be difficult to exclude a strike where workmen enter the premises of the employment and refuse to take their tools in hand and start their usual work. Basically, this is related to the pen down strike. Our understanding of strike is that people do not enter the workplace. Right? For example, hunger strike, wherein they will sit at the entrance of the workplace and they do not work. But it's not like that. The court said that in this case, what happened? The employees entered the bank and penned down. For example, they are not doing any work. There is a big line of customers waiting there, and it's a 1960 case. At that time, the most of the work was to be done by in a manual way. So this pen down strike, literally it was penned down. That means they did not took a pen or any other writing material. So even that was considered as a strike. Right now, very important topic here is that whether a strike can be legal or illegal. So under section 22, strikes and lockouts are prohibited. I will come with this particular thing, that strikes and lockouts are prohibited as far as certain conditions are not satisfied. For example, industries are classified in two groups. One is public utility services, and second, such industries which are not included within the meaning of public utility services. Now, the general provisions is that as far as the strikes and lockout is concerned, is that a notice has to be given. Right? A notice has to be given for going on to a strike, especially if it relates to public utility services. Now, without giving notice of strike to the employer within 6 weeks before striking, or within 14 days of giving the notice, or before the expiry of the date of strike specified in such notice. So, such strikes could be called out as illegal strikes. There is also an informal term called as a flash strike, wherein no notice is given, wherein the persons could be declared, or the strike could be declared as illegal. Right? An important thing is to be considered here is that whether the strike, which is legal and justified, are the workers entitled to wages? This was being answered in Crompton Greaves Limited. Crompton Greaves, the fan company, in 1978. case. So in that case, the court has specifically said yes, the workers are entitled to the wages of whatever days the strike has been going on. Going to another definition, that is the lockout. Now, just as the way the workers conduct the strike, lockout is there from the employer side. The employers shut down the workplace as a punishment for employees or threaten the employees. Definition is said, it means a temporary closing of a place of employment or suspension of work or the refusal by an employer. Obviously, such lockout which is there, now it cannot be done in any public utility services, right? Obviously, there is also a penalty for lockout. Any employer who commences a lockout is illegal under the act, and punishment is maximum 1 month imprisonment or a fine of 1,000 rupees. Going to the next definition, that is layoff, right? Now, the definition given in the act is layoff means failure, refusal or inability of the employer on account of shortage of coal, power, raw materials, accumulation of stocks or the breakdown of machinery or natural calamity. This thing you may have heard in the recent times. For example, in the recent this COVID pandemic, some of the industries are actually resorting to this layoff, wherein they are temporary suspension of the employers the employees by saying that they are not able to work. So therefore, a layoff is missed. But the question is that whether this is illegal. So yes, in some cases it is legal only if it is done in the good faith. How? Let us have a look on what are the ingredients of a valid layoff. First, shortage of coal, power, raw materials. It can obviously happen. Accumulation of stock. Sometimes it may happen that the overproduction is there of certain their inventory, and unless until that stock is cleared, so it will just add up or piled up. So in order to have a balance, they can stop the work or they can lay off certain employees. Breakdown of machinery, natural calamity or any other connected reason. Any other connected reason is used nowadays as far as this COVID pandemic is concerned. Anyways, so this particular layoff is controversial, right? If it is misused by the employer. Why? A case called as Workmen of Diwan Tea Estate versus the management, it was held that the right to lay off cannot be claimed as a right of the employer. Now, it has to be specifically provided of by the contract of employment or by the statute. So they have to justify on what basis the layoff is being there, and then only they can proceed towards this particular thing. Now, there are certain things that in layoff you need to give compensation. It also depends upon the status of the workman, that whether he is a casual person, his appointment is casual or permanent, or his type, whether it is continuous or not, and the number of workmen in the industrial establishment. There are 3 groups of workmen employed, where the number of workmen is less than 50, second 50 to 100, and third 100 or more. Right. Next, we will come to this term called as the retrenchment. It means termination by the employer of the services of workmen for any reason whatsoever, otherwise than as punishment inflicted by disciplinary action, but does not include voluntary retirement or reaching the age of superannuation, relating to retirement only. Right. Now, the definition of this retrenchment has given us certain features of the retrenchment term. That is, it means the termination, and this termination is not by result of a disciplinary action. Right. Next term we could call it is next term in this particular thing is called as the closure. Now, before going to the closure, let me also give you certain principles given of retrenchment in this case law called as the Workmen of Subong Tea Estate versus Subong Tea Estate. The following principles relating to retrenchment are given as that the management can retrench its employees only for the proper reasons. So therefore it cannot be by way of any other motive. Second, it's a valid exercise. Nobody is saying that it's an illegal thing. But then they have to justify it reasonably. So, for example, workmen may become surplus on the ground of rationalization on the group of economy reasonably and bona fide adopted by the management or other industrial trade reasons. Say, for example, newspaper industry, right? So everybody knows that the newspapers, because of the onslaught of this digital technology, there were many of the cases where the newspaper employees were being shut. These industries were being shut. Now they had to actually prepare, a particular proper plan, or they had to actually prepare justification or a very detailed plan as to how these workers could be retrenched. So it is not an arbitrary decision. Just one fine day you cannot say that the industry is now closed. No, has to be a very detailed exercise. The next topic which we are going to study, that is the Trade Unions Act. So the role of trade union also becomes important in this particular retrenchment exercise. Next, closure. It's very simple: permanent closing down of a place of business. Obviously, that is also okay. Now, some case studies as far as industrial dispute is concerned. We have discussed this. The most basic case which I would refer here is the Maruti case. What happened in this case is that in July 2012, the Maruti's Manesar plant was being hit by violence as workers in this particular auto factories attacked the supervisors, and it injured more than 100 managers, including Japanese delegates, and also they killed one HR official of the company. So it is worst ever for the Maruti Suzuki, as you know it, since it began its operation in 1983. More than 500 workers were dismissed because of this. They started their this plant after a few months, but then this is considered to be a very big case of industrial dispute. Next case is the Honda Motors and Scooters India case. Now what happened in this? In 2010, security guard, security personnel, he misbehaved with a worker. Now what in this particular case, now since this news spread on like a wildfire, the workers went on a strike and they halted the production. But the management was very successful in this case, is that no violence was reported, and they managed to restart their operations by their intervention and using of conciliation methods, and the work was started within the next 24 hours. So these are some of a couple of case laws relating to this industrial disputes. Another case study is the Jet Airways retrenchment case in October 2008, and also in recently, I guess in 2019, the Jet Airways was officially closed, and many of the workers received the notice of termination. So this retrenchment case, it is still going on in the various authorities. So this is all about the revision of the Industrial Disputes Act. Next time we will study or have a revision of the Trade Unions Act. Make sure that you revise all the important topics and also study the other subjects. Best of luck. We'll meet very soon.